Lachowski i Piątkowski o prawie międzynarodowym. Podcast Wydziału Prawa i Administracji Uniwersytetu Łódzkiego oraz portalu Obserwator Międzynarodowy.
Joined the Global Law and Governance Bachelor's Program at the Faculty of Law and Administration, University of Łódź, and gain the expertise to shape global policy and build a career where law meets international impact.
Good morning, everyone, ladies and gentlemen. Welcome to another episode of our podcast about international law. And we have another special guest with us, Dr. Petr Stejskal from Czech Republic, Olomouc, member of the Center of Humanitarian and Operational Law. We strongly recommend to check the websites, to basically follow the activities of Dr. Stejskal, who is a renowned member of the Czech Academy of International Law. And today we're going to discuss his book about the application of foreign investment protection in times of armed conflict, book which was published in Palgrave Publishing House. And we're looking forward to know something about this, I would say, maybe a little bit technical at first hindsight topic, but on the other hand, as we discover, there are much more to the foreign investment, the relationship between the investment and the armed conflict. I hope we are going to learn a few interesting facts, which will also be kind of provoking in the light of IHL, human rights, and even general international law.
Okay, so Dr. Stejskal, dear Petr, thank you for joining us today for this podcast.
Thank you very much for inviting me. It's a pleasure to be in Łódź again.
Great. So to begin with our discussion, because one of the most important notions that you are dealing with in your book is called in the acronym BIT, that is Bilateral Investment Treaties. According to different sources, the first one was concluded between Pakistan and Germany in 1959. So we have quite a lot of decades of those BITs in action. However, this, I would say, the second start was concluded with the end of the Cold War in 1990. So different, economic, political transformation in Europe, also in the rest parts of the world. So, first of all, we would like to ask you, could you explain what actually this term BIT mean? And maybe one more sub-question, because also it is very interesting that in your book you are dealing with many case law which are dealt by different tribunals, different investment arbitrary courts. So can you explain this, I would say, infrastructure, this legal architecture of those arbitrary investment bodies, as well as BIT as a term? So please.
Okay, I'll try to be brief. Please stop me if I'm not. As you mentioned, this field is based on BITs, bilateral investment treaties, and the field is quite unconventional in the case, or in the sense that the law is based on the net of thousands of BITs, which are being concluded between states, but private entities, investors are the beneficiaries from those treaties. And not only that they have rights, substantive rights of protection from those treaties, they also have a procedural stance against the states for their sovereign acts. So the general idea is on the side of the states, why they conclude such a treaties which limit their sovereign power in their own territory, is to motivate foreign investments flow into their territory, because it goes with money, work positions, know-how, technology. And on the other hand, foreign investors, they need some kind of predictability of the law, of the policy of the state for long term. And these investment treaties are supposed to guarantee that predictability. So there are standards such as full protection and security, war clauses, non-discrimination, protection against expropriation. So whatever is not guaranteed by the law, or national law, or European law, for example, or human rights law, it should be guaranteed by these treaties. If there is some conduct which damages the investment, Contrary to the BIT, as you already indicated, there is investment arbitration, which is quite a strong tool in comparison to other fields of law, international law. It's quite effective because private entity, if I am an investor, a German investor in Pakistan, and my company is being, for example, expropriated or confiscated, I can initiate from my position proceedings on international level, treaty-based, against the state. And just the last thing, what is also making it strong, most of the decisions of arbitral tribunals are enforceable thanks to the New York Convention, so it can be enforced on national level as a national decision against the property of the state. And sorry, you ask also about this mechanism, how it works. It's based, or these cases are being decided by ad hoc tribunals, which are established for each case separately. So there is no general permanent court or institution. It can be administered by Permanent Court of Arbitration, which is administering the cases but not deciding. So it's usually composed of 3 arbiters. They are also the 2 arbiters are appointed by the parties to the dispute. So it's ad hoc, and there is also some tendency to make it more permanent. But so far, that's what we have.
Here, just to remind that I believe quite recently there was a quite huge decision in Poland because Poland has a BAT with Australia. And in 2016, Australia was trying to build a mine in Poland, but actually due to the decision of the Polish government, this construction was suspended or was completely cancelled. And I believe just recently, maybe not that very recently, there was a huge discussion inside the Polish media, internet, and information that tribunal ordered Poland to pay a significant amount of money to the private company. Why is that? And in fact, in Poland, we also have maybe not that very nice, if we are looking for the perspective of the state, situation when Poland was facing significant hours, was obliged to pay a significant amount of money. And as you said, this is quite efficient mechanism because I believe at last point in the US, they could basically enforce the judgment in a way that could take your gold or your central bank reserves that are located inside the United States. So it's one of the, I believe, most effective tools and fascinating here. But your book is about the armed conflicts, and the armed conflicts are, let's say, this ultimate emergency situation. And your research is focusing on the specific situation. We have the armed conflict, the BAT is still ongoing. Obviously, it's affecting a lot of situation. And obviously, there are certain rules of interference, how the armed conflict is basically, what kind of activity is triggered by that? Does it mean the treaty became suspended, is null and void, or it's been terminated permanently? So what we could say generally about the impact of the situation of the armed conflict on the BIT applicability? Because obviously BIT is, let's say, from the viewpoint of war, it's not a priority situation, but it's, in fact, it could have obviously other very significant impact. And also a private question for me is that you mentioned those ad hoc tribunals, and there could be a lot of those tribunals composing of different persons elected to be in the panels. And I just am curious that whatever there is a possibility that, for instance, a state may say, no, there is no armed conflict in our territory, especially in the context of non-international conflict. We're fully controlling the area. This is just like law enforcement situation, some kind of social interest, but we got it fully under control. And the panel said, no, it's actually the situation of armed conflict. And do you think that this creates some kind of friction between the state which is stating there is no grounds to say that this situation is an armed conflict, and the panel of the people said, no, we disagree. We believe there is an armed conflict, and it has some impact on the BAT.
Well, starting with your first question, generally, in most cases, or in the cases I was analyzing, the BIT do not cease to apply as a consequence of emergence of armed conflict. There are several doctrines which can be utilized. There is this effect of armed conflicts on treaties doctrine, which there is some presumption of applicability. It's also draft articles are being written or have been written by the IOC on the topic. And my view is that normally this presumption of applicability is not rebutted by the emergence of armed conflict in most of the BITs, because in fact, many of these treaties, they actually refer to war. They have specific clauses, which are called war clauses, simply, and they refer to civil disturbance and wars very often. So this is a strong evidence that they were drafted, taking into account it might apply during the armed conflict. Also, Vienna Convention on Law of Treaties contains some termination suspension clauses, but these are very strict to develop. So basically, in most of the cases, and as was also confirmed by many decisions we have had since Crimea occupation and also Middle Eastern Arab wars, these are normally applied by tribunals in context of hostilities. To your question that the state might deny existence of armed conflict, I understand that this is from the political perspective quite likely in terms of non-international armed conflict, where the state party doesn't want to grant the rebels some status, some legal status under international law. But I think that in investment arbitration, actually IHL application would be in interest of the state, because if there is a claim which is raised against the state for the distraction of foreign investment during the hostilities, investment law might not grant the state so many exemptions how to evade the claim, but actually I argue in my book that IHL contains some exceptions that the state might want to actually raise, military necessity, for example, and that raises a lot of questions. You mentioned one of the issues that maybe investment tribunal will argue, no, this is armed conflict. Unfortunately, if I can say it that way, tribunals are really trying to defer themselves from actually having any say, any word on the war. They are trying to be strictly in their jurisdiction to apply and interpret the BIT, and they are not classifying the conflict. They are not using the vocabulary of IHL. They are really trying to be isolated from that, which is also something I'm pointing out, that they might delve also to IHL issues as part of interpretation of BIT. But generally, the jurisdiction of the tribunals is limited to the interpretation application of the particular BIT. So they are in no way, they don't want to qualify or say anything on the existence of armed conflict. They are very careful. Maximum they say in the Crimean cases is, for example, that the respondent party is controlling the territory, but they do not usually qualify that as IHL armed conflict and which rules apply.
In your book, one of the biggest parts of your book deals with a lot of disputes that are based on the Ukraine-Russia BIT, which actually was concluded in 1990s, in the second part of this decade, therefore in a totally different geopolitical landscape, of course, without any armed conflict between Russia and Ukraine. And also in the book, there is some kind of a division between the cases which were brought after the annexation of Crimea and then after the full-scale invasion was waged by the Russian army after 24th February 2022. So our question relates first of all to the BIT itself, this Russian-Ukrainian BIT. What does it contain, the content of this BIT? But at the same time, we would like to ask you whether do you perceive this BIT, the application of the BIT by especially the Ukrainian different investors or the state itself as a part of a bigger picture of the lawfare of Ukraine against Russia between on the basis of different mechanisms, international public law between Russia and Ukraine before the ICJ or under human rights law. We of course, we can recall the European Court of Human Rights in this case, because actually having in mind your thesis, I would say that, for instance, as we were discussing the efficiency of BIT and those investment arbitraries, we can argue that actually when it comes to the question of reparation, possible war reparation for Ukraine from Russia, that this kind of mechanism, of course, it cannot substitute, but actually it contributes to the bigger picture of this lawfare between Ukraine and Russia on different layers of international law. So coming back to the main question, please just define or try to describe this BIT between Ukraine and Russia and some of the case law that you dealt with in your book.
Mm-hmm. So the BIT concluded between Ukraine and Russia, it could be described as a standard BIT, similar to other. There are some clauses, substantive rights, which are repeated in almost every BIT. So it's a full protection and security law. It's a protection against expropriation. So expropriation is possible, but for all these standards that we know, due compensation based on law, etc., etc. There are also some clauses protecting investors against discrimination, and there is also this very important mechanism of dispute settlement where the investor can raise the claim against Russia. What is a tricky part with every investment treaty is its scope of application, because normally investment treaty is supposed to protect the investors of the other state party in your own territory. So Ukrainian investors are protected in Russian territory and vice versa. So that's the basic design of almost every investment treaty. But the problem with which emanated after the occupation of Crimea is that actually in order to apply the obligations of Russia from that treaty to Crimea, we somehow have to develop that it's part of Russian territory. And this is the critical question here, because in contrary to European Convention on Human Rights, for example, which operates with the term territory and jurisdiction, BITs operate only with the term territory. So they say that the state parties shall apply these conditions, these obligations in their respective territories. Of course, these definitions are somehow wider. They also contain maritime zones, etc. But there's the tricky part here, which I'm analyzing in detail. The tribunals that started to hear a lot of cases against Russia after 2014, after the annexation of Crimea, because what happened, just very briefly, is that Crimean authorities and also under the control of Russia, they started to confiscate a lot of assets of Ukrainian companies. It has been petrol stations, properties, hotels, airports. A lot of properties, immovable properties, has been seized by local authorities, and these foreign investors, they initiate arbitrations to get compensation for the breach of expropriation clause. One tricky part, these claimants are actually Ukrainian investors, so they post themselves as being foreign investors in quasi-Russian territory of Crimea. So that's one tricky part of that. And the other part is for the tribunal, how to actually deal with that. Maybe we will talk about that also later, but the tribunals, they were very careful to qualify Crimea as a Russian territory. Of course, they even cannot, because it's by law not Russian territory. But if that's Ukrainian territory, you cannot apply Russian obligations on Ukrainian territory. So the tribunals, each of them, also that's maybe the reason or consequence, because they are ad hoc tribunals, every tribunal had a slightly different view. They somehow constructed the application of the treaties in territory controlled by Russia. And the reasoning differs, but they usually base it on the object and purpose of the treaty, that the term territory should be interpreted in a wider sense, in a theological manner, that it also covers territories under de facto control of states. But actually my research led to the opposite conclusion. Even though that I agree as in terms of legitimacy or as a human with these claims, and I'm happy as a normal person, as Petr Stejskal, I'm happy that these companies were winning the cases, because that's actually tens or hundreds of millions of dollars, which are now being entitled to be paid by Russia. As a lawyer, as a positivistic lawyer, if I interpreted the term territory as used in BITs in accordance with Vienna Convention on the Law of Treaties, my conclusion was that in typical treaty of investment protection, in typical BIT, it really refers to sovereign territory of state. So, in fact, what happened, national Ukrainian investors being damaged in territory of Ukraine were entitled to be paid compensation from Russia.
So they became actually the foreign investors in Russia instead of being domestic in their domestic jurisdiction and sovereign territory of Ukraine.
Exactly.
And because it's a very interesting issue, I would like to make some follow-up question because about this territory issue, because you also dealt with in one of the chapters of your book with territory issue, because it is very crucial from the point of view of Jus Cogens norm, and especially the prohibition of aggression in this term, and especially the principle of non-recognition of unlawful situation. So can you elaborate more on this in terms of the question of territory? Because of course we are talking about the Russian aggression against Ukraine and its consequences, but in theory and in practice there are also other places, like let's say in the EU we have Cyprus with the part of Cyprus being officially occupied by Turkey, but at the same time, it is like the quasi-state. So in theory, there also can be some foreign investment. So the issue, the picture is much broader than just the case of Russia and Ukraine.
Exactly, as you say, it can have some repercussions for future cases. But the non-recognition principle that you mentioned is actually a very good point, because by treating occupied Crimean territory as Russian territory would actually go against that principle of non-recognition. That's probably why tribunals were very careful in their argumentation. They didn't, in their reasoning, say Crimea is Russian territory. Even the claimants, the Ukrainian companies, interestingly, very often state-owned Ukrainian companies. So many of these claimants raising claims against Russia are energy companies or banks owned by Ukrainian government or Ukrainian state. They claim in those claims that for the purposes of the application of the treaty, they consider Crimea to be Russian territory, just for the purposes of interpretation of the treaty. But the tribunals didn't go even that far. They were operating with the terms territory under control. And some of the tribunals had a quite specific construction of a joint combined geographical area where the treaty applies of both Russia and Ukraine. I don't really agree with that notion, because obligations of one state apply in its own territory, obligations of other state apply in its own territory, and we cannot simply make a fluid combined territory, because we have to distinguish obligations of each of the state party. But that's why, of course, the tribunals were in a difficult position, because on the one hand, they wanted to develop the applicability of the treaty, but they couldn't run against this non-recognition principle. And they also cannot have anything said on the status of the territory, because it would also run against another principle, the limitation of the jurisdiction of the tribunal to the application of the treaty. So they cannot delve or have some reasoning on what is the status of Crimea. That's also out of their jurisdiction. So that's why they are quite very careful on how they call it, and usually they call it in quite an unusual way. But we can maybe summarize that very often they operate with the term controlled territory, under de facto control, and they say that the term territory, as defined in the BIT, also means de facto controlled territory, and they don't say it's Russian territory very often.
Thank you very much for this explanation, because it's also kind of proving that the different bodies that are dealing with international law could have different opinions on the same, let's say, term, the territory. What does it mean? What about the occupation, and etc. So I think it is worth to follow the rulings of the arbitrary tribunals, because they are not just technical issues. They could render an important opinions on the general international law. And as you mentioned, some of them could be really controversial, like stating that Crimea is part of the Russian territory, which goes, as Tomek said, fully against the principle of prohibition of recognizing the unlawful situation, which is considered to be one of the foundations of the modern international law. And it protects the Jus Cogens framework and prohibition of aggression, etc. But coming back to the IHL word, as you mentioned, IHL might be, in fact, quite useful in those cases, especially if we consider it from the perspective of the state, which is possibly in most cases a respondent. So someone who is defending an entity which is defending for certain charge on a breach on the BIT. But you also mentioned other bodies of international law, and this mixture is really interesting in this way that, for instance, if we have a situation of occupation, sometimes the expropriation under the law of the occupation might be lawful. Or if we have an active zone of armed conflict and we have conduct of hostilities, you may destroy, I don't know, an oil extraction facility, which is also protected investment of some foreign body, foreign enterprise. So how the tribunals may resolve the dilemmas, because on the other hand, we understand, as you mentioned, they do have certain independence. They always have this reservation, which is only for the purpose of applying the BAT in this case. Our jurisdiction is limited. But on the other hand, can they fully avoid those, I would say, very intriguing legal questions from the IHL, that they cannot just go away and cannot use the military objective in their own independent fashion? But as you said, they could, that sometimes they are making some independent, let's say, reviews of some terms. But what about the situation that they are dealing with the purely IHL situation, and then how they could apply the IHL? What about the human rights in this context? And also, a last thing, which is also interesting in terms of non-state actors, there is also a question of due diligence. So it kind of says that the state is really in not very favorable position if there is some kind of rebellion, because it has a duty to protect the enterprise of foreign investor, the buildings, the personnel, I don't know, the processing, extraction capacities, like the material buildings. And it's sometimes very hard for the government to do it. So what is your opinion on those, let's say, little bit technical aspects, but nevertheless important? Do you think that the tribunals are dealing well in those questions in their jurisprudence, or you kind of are more critical about it?
My view is that given the fact that so many arbitrations are now being connected to hostilities or to situations of armed conflict, my observation is that the tribunals are really trying to omit or escape the reference to IHL. Of course, one important fact is that their jurisdiction is strictly limited to the application and interpretation of the investment treaty, and that's it. But on the other hand, my view is that if we are interpreting a term in BIT which is referring to the situation of armed conflict, such as the war clause, which is very often, especially in the extended form, counting with the situation of armed conflict, then in the interpretation of the terms such as necessity of the situation, I argue that the tribunals, as part of the process of interpretation, should have a look at the terms that are also used in IHL. But my observation is that the tribunals are not using the IHL vocabulary in these cases, but also to defend them, neither the claimants are actually referring to IHL. There are just very few, let's say, first messages, early birds, let's say. We could see that in the case of Strabag versus Libya, where the claimant suffered a lot of losses during the Arab Spring because the construction sites were looted by many actors, by the armed forces, by the rebel groups, non-state actors. And one of the arguments in one of these incidents of the state, of the defendant, was that actually it was in the military necessity to target some of the facilities of the construction sites in order to stop the rebel forces that have been marching towards the capital city. So that was a very nice opportunity for the tribunal to actually, when interpreting BIT term, completely in accordance with its jurisdiction, to refer also to IHL, because it was directly raised by the defendant state. But the tribunal didn't do so. The tribunal concluded it has a lack of evidence. There is a lack of evidence. It is usually the case in situations of armed conflict. Investor is away. Its property is being hit, destroyed, looted by many actors. So it's very difficult, demanding, and also technically demanding to collect evidence of who did what. But in that case, the tribunal didn't elaborate on military necessity. But actually, quite surprisingly or paradoxically, the very first investor-state arbitration, AAPL versus Sri Lanka, concerned a situation of armed violence. It was the claim which was tracing back to the incident where a private company, private farm, shrimp farm on Sri Lanka suffered damage and also the death of employees during the counter-insurgency operation of Sri Lanka's special forces. So the very first arbitration we have actually concerned armed conflict. Since then, there were not many such cases. Arbitrations were mainly dealing with, let's say, conventional situations, economical, legal infringement with foreign investments. But after Crimea, everything changed, and we have also this now the new wave of arbitrations relating to either situation in occupied territory of Crimea and Eastern Ukraine or the Middle East. So to answer your question, I argue that as investment tribunals do in other fields, when they are referring to human rights law or environmental law, when interpreting investment treaty commitments, I think that in cases relating to armed violence, they should refer more also to notions of IHL when needed, of course. And it all is still part of interpretation. It's still part of Article 31, paragraph 1, letter C, in accordance with the principle of systematic integration or interpretation, when interpreting the term, which very much resembles the field of IHL, and especially when the state party or the party to the claim actually refers to that claim or to that notion. We shouldn't ignore this field of law which is applicable. The tribunal cannot apply the field as such. We know from other areas that, for example, European Court of Human Rights is very active in elaborating on IHL issues when dealing with human rights law claims. So there is a long pages of IHL elaboration of detention and other fields. So that might be the other extreme. But I think that investment tribunals are really careful about mentioning IHL at all. So they're completely neglecting this area of law. But as these cases might have also learned or educated us as a community of academics, but also practitioners, that actually is a viable option to litigate war by a private entity through investment arbitration. So we might have more and more cases from that field, and then it will be for the arbitrators the question actually whether they shouldn't really refer to IHL, which can be, as I mentioned at the beginning, it can be actually, let's say, something in favor of the defendant state to maybe refer to military necessity in order to refuse the claim.
Yeah, we talked a lot about international armed conflicts, non-international armed conflicts, the tribunal views. And right now I would like to ask a question about from the position of a state. So actually, what practical steps would you recommend for the state to comply with its BIT obligation and commitments in terms of a potential armed conflict? Because of course sometimes they are very dynamic and maybe a state cannot prepare itself in 100%, but at the same time a state should foresee any kind of legal risks in this situation. So what are your recommendations in this field?
It also partially goes back to Mateusz's question on due diligence, because one way, or it depends on which standard of protection is being in question, whether it's a full protection and security, which is a very typical clause, which gives states a positive obligation to protect private investors from the harm of third parties. And this standard is due diligence. So it might be even out of the hand of the state to actually protect the investment. So one way is to collect sufficient evidence of the situation at the place, because the Middle Eastern and North African cases showed that not every attack of rebels on foreign investment is then being held as a breach of the treaty, because in some situations, if the situation is overwhelming, the state capacity is simply not enough to protect every investor, then the standard might not be breached. It's still due diligence standard, it's not strict liability. So that's one way to do that, to be careful about distributing the state sources and capacities equally across all investors, because in one of the cases, I believe it was Ampal versus Egypt, when the Trans-Sinai pipeline, gas pipeline, which goes to Israel, was severely damaged by several explosions, and the tribunal was comparing what protection was given to this area and what protection was given to this area. So when the state claims, I had no soldiers to protect this facility, but if in the neighboring city there is a battalion of soldiers, that might be something which is then being raised. But to answer your question, maybe in a simple way, all is also connected with the chain of command. As you already mentioned, during hostilities, nobody is really taking care of the ownership of particular facility. But unfortunately for these scenarios, we have a globalized world, and private companies are running most of the services and companies and facilities. But if you are a commander and you are the chief of the army, you are simply taking into account different perspectives, different considerations, and you might not be even aware of foreign investment protection. So I think that's actually the question you posed is actually a big challenge for the states, because I believe that the states are only now learning that actually investment arbitration can be raised after the conflict against them. So of course, maybe the most pragmatic way would be to redraft BITs. I didn't mention that, but BITs actually, they contain also a lot of exemptions. Some of the BITs, they contain so-called non-precluded measures clauses, which allow states to take certain measures which are necessary to protect essential interests of the states. So these clauses might be included in the treaties, security exceptions, let's say. But then when the hostilities emerge, me as a state, if I was planning actions, military operations, of course, from the position of a commander, I don't have any chance to do that because I'm not aware of the ownership. But on a more strategic level, I would try to actually use IHL as a defense, because, of course, IHL is being perceived as a limitation, but actually it's authorization to use lethal force, if you consider it from that perspective, and it contains a lot of exemptions based on military necessity. So I would precisely select and carefully select my targets based on military necessity, and do not discriminate between the nationality of the investors. But what was the Middle Eastern cases were quite similar or simpler in a way that it was very often the forces, the armed forces of the states, which simply looted. So have under control your own forces. That's maybe the simple message for these countries.
So, as you, I think our viewers fully agree that the BATs are serious international instruments, which Russia and Ukraine case also shown are very, I would say, effective mechanism to enforce, designated to bypass those questions regarding the sovereign immunity, questions regarding the difficult dilemmas regarding the state responsibility, and etc. It is done by purpose, but on the other hand, during the times of armed conflict, the situation could get very tricky, and the states shall also somehow, in my opinion, this is conclusion for what you said, foreseen the possibility that, well, the foreign investments still need to be protected in this way or another. If it's not possible to protect it, then we need to think about alternative mechanism, just to maintain this due diligence threshold. And as you mentioned, to control its own armed forces in a way that they are aware about that this also matters. It is interesting that if, for instance, we look at the training of the armed forces, the IHL, human rights, obviously, but today you also pointed out that the armed forces shall be aware also about maybe international investment law, because those actions could have a very serious consequences, and those consequences are hard to basically be challenged. The enforcement is so standardized, and this is something that I believe the states and the armed forces shall also take into account.
One option I maybe forgot how to solve this dilemma is to actively terminate the treaty, because I mentioned at the beginning that automatically those treaties do not cease to apply. But actually many of these treaties, they contain termination, suspension, sunset clauses. And what is actually Ukraine did, I think it was already 2 years ago, they actually initiated the termination of the Russian-Ukrainian treaty. So even though it helped Ukrainian investors and companies to actually lodge all these claims, for some reason, the Ukrainian government decided to suspend or terminate, I'm not sure now, this treaty. So that could be a way. Of course, there are some expiry, let's say sunset, period of time where the treaty still applies, because for foreign investor you cannot simply terminate it a day from day. But it could be also the way, at least, to be aware of the treaties that are in force. It can be 20, 30 treaties. Poland, for example, it has a lot of investment treaties in force, including with Ukraine, for example, not with Russia, but also with Iran, for example. So really there are some countries which might be involved in armed conflict, and their BITs in force.
Who knows, maybe this termination got something to do with the Ukrainian plans for offensive and maybe trying to get the war to the Russian territories, and the situation could be reversed somehow. I'm afraid that's all for today, for this very interesting talks, but obviously any remaining questions are to be resolved by reading the book, The Application of the Foreign Investment Protection Times of Armed Conflict. So from our side, we would like to once again welcome Dr. Stejskal for being our humble guest in our humble podcast, a small podcast. We obviously invite you to follow Dr. Stejskal research work and to follow the activities of the Psychol Center at the Olomouc. There's plenty of them. So even this summer, 2 schools, I believe, right? 2 schools, workshop, yes, and a lot of is happening in Olomouc in Czech Republic. So if you are fans of international law, I do believe the activities of Petr Stejskal and the Psychol will definitely be something very interesting for you. So from our side, that's everything for today. Please follow us for more content on international law. And for today, once again, thank you, Petr, for being with us today.
I thank you for having me, for your hospitality. I must say that the cooperation between Olomouc and Lodz is actually very intensive. So some of the activities that we do are possible just thanks to our cooperation. So thank you again very much for having me in Lodz, and see you again, either again here or in Olomouc.
Thank you very much. Take care.